on the application of Emmanuel School, Limited TA, Emmanuel School and others, and the Chancellor of the Exchequer.
Mr. Bridge.
My lords, my lady, I appear for the Claim 1 appellants, leading Ms. FSG. Could I just flag at the outset that my clients have benefit of anonymity as continued by Lord Justice Lewison in granting permission to appeal, and they have referred to as BYL and BAU, and the father BAU is in court today behind me as well. My own friend Mr. Quintavale appears for the Claim 3 appellants, and the government parties are represented at this hearing by Sir James Eadie, King's Counsel, Ms. Hannett, King's Counsel, Mr. Pobjoy, King's Counsel, Mr. Parker, and Ms. Sheridan. My lords, my lady, by way of housekeeping, your lordships, your ladyship should have a core bundle of 711 pages.
Well, I don't want to hear about the bundles, Mr. Bridge, but I do want to raise 3 points, if I may, myself. The first point is that the court sent an email to all parties a few days ago informing you that we wanted the parties to be aware that Lord Justice Singh's son is a civil servant currently working at HM Treasury. He has not worked on the issue with which this case is concerned, and Lord Justice Singh has not discussed and will not discuss this case with him. In addition, the other members of the court have family members attending or likely to attend private schools. None of the members of the court is, however, now paying or is likely in the future to pay private school fees. The court does not see that any of these matters should disqualify them from hearing the appeal, and we have heard from your clients, Mr. Bridge, and from the government parties to confirm that they do not see that as a problem. We have not, however, heard from Mr. Quintavale's clients, and I would like to be assured that there is no question of any concern.
My lord, there's no concern at all. I don't know why the email confirming that there wasn't a concern didn't reach your lordships.
Thank you very much. The second issue concerns the new evidence. Both parties have put in new evidence. As far as we're concerned, we would not want to spend a great deal of time talking about this new evidence. It updates us. We should look at it depending as anybody has any objections to that happening. No? Good. And the third question is as to the timetable. Once again, we were presented with a timetable for the oral argument, which was agreed by your clients, Mr. Bridge, and the government parties, but not, as I understand it, agreed by Mr. Quintavale. We would like to know that the timetable is agreed, because there is no longer than 2 days between 10:30 and 4:15 with the usual breaks available for the hearing of this case. Mr. Quintavale.
My lord, the only issue was this, that if it became apparent that the Claim 1 appeal was able to make its submissions in shorter time than was budgeted for, that maybe a little bit more time would be available for us. That was the only...
We're always very flexible, Mr. Quintavale, but what we don't want is anybody saying that it's unfair afterwards.
It's going to be very difficult to get through 8 grounds of appeal, but I'll try my hardest to do so.
Very good, thank you. Mr. Bridge.
My lord, I'm grateful. My lords, my lady, this appeal is against, or these appeals are against the order of the Divisional Court made on the 13th of June 2025, dismissing all the claims for judicial review, challenging the statutory provisions which made VAT payable on private school fees, and that order is at page 155 of the core bundle. The appeals have been brought by my clients, who are members of the Haredi Jewish community, and by the group of claimants from the evangelical Christian community, who are represented by Mr. Quintavale. I would propose to address the court on behalf of the C1 appellants under the following headings. First of all, a brief introduction to the issues in our appeal. Secondly, the challenge provisions. Thirdly, the factual background of the appellants and the community. Fourthly, Article 14 of the Convention and the proper approach of this court to the proportionality assessment it requires, looking briefly at the Supreme Court's judgment in Schvidler. And then fifthly, the outcome, including why the Divisional Court were wrong in our case to find justification. and finally, relief, which I will take very briefly indeed. My lords, my lady, on the first heading of the introduction, the Claim 1 appellants I represent do not challenge on this appeal the general application of VAT to private school fees. My client's case is that the challenge provisions breach Article 14 of the European Convention in the Flimenos sense in relation to the application of VAT to the Haredi Jewish schools, because these schools and their users have been treated in the same way as other private schools and their users, despite being in a significantly different position to them without objective and reasonable justification. In summary, we say the Divisional Court was right to find that our community is in a significantly different position to the majority of private school users. But the Divisional Court was wrong to find that the government parties have justified the failure to treat our community differently. And we say further that this is clearly a case, following the Supreme Court's guidance in Svidler, where this court ought now to conduct a fresh proportionality assessment for itself. Turning then to the challenge provisions, our second heading, they are now sections 47 to 49 of the Finance Act 2005, which are in the Court's Authorities Bundle, tab 8, page 83 to 86. And they are addressed by the Divisional Court at paragraphs 8 to 14 of the judgment below, at page 164 to 165 of the core bundle. If I could go there first, please. So page 164 of the core bundle. The Divisional Court, of course, noted that at the time these challenges were launched, the target was a budget resolution. But by the time of the hearing below, the legal authority, the sole legal basis, as the Divisional Court put it in paragraph 11, for the levying of VAT on private school fees became sections 47 to 49 of the Act, of the Finance Act 2025. And paragraph 9 of the Divisional Court's judgment summarises how that change, a tax change, as the Divisional Court called it, was given effect, providing for amendments to Schedule 9 to the Value Added Tax Act 1994 by removing the exception from VAT in relation to supplies of education and vocational training by private schools and related boarding and lodging. And so if we look briefly at the sections themselves, page 83 of the Authorities Bundle, Court has that?
Yes.
Grateful. And we see that the heading of section 47, removal of exemption for private school fees, VATA 1994 is amended as follows, and then we see how the exceptions were then amended in the table that follows, and the definition of a private school, which follows in the notes. Nothing about the technical language of the statute matters for the purposes of our appeal in our submission. So what section 47 did in substance was to introduce an exception to the exemptions. It identified supply which would be exempt, but because of the application of the exceptions is no longer exempt. If we go back to the Divisional Court judgment, which we have at page 164 of the core bundle.
You can just refer to paragraph numbers in the Divisional Court judgment. We're very familiar with it.
Grateful, my lord. So paragraph 11, as we saw, picks up the story with the enactment of the Finance Act. And then over at paragraph 12, no needs to consider challenge as it was originally formulated. Paragraph 13, the parties competed in how they characterised the measure. The Divisional Court preferred to speak more neutrally of a tax change, and we accept and adopt respectfully that description. The compatibility of this change with convention rights depends on its substance, not any label attached to it. Then at paragraph 14, the Divisional Court noted that the claimants placed some reliance on the fact that no other Council of Europe contracting state imposes the VAT or any similar tax, and found that neither side could draw much from this, primarily because most Council of Europe states are in the European Union and EU member states cannot impose VAT. And we respectfully do not challenge that conclusion in this appeal. If We move forward then to paragraph 17 of the Divisional Court's judgment. We have the policy background. And paragraph 18 flags the Labour Party manifesto commitment. Labour will end the VAT exemption and business rates relief for private schools to invest in our state schools. And the Divisional Court then referred to the evidence from the government parties as to 4 interlocking principles on which the policy was based. Paragraph 19, at first, to raise revenue, support public finances and help deliver the government's commitments relating to education and young people, including the 94% of school children who attend state schools. The forecast was that it would raise an average of 1.6 billion per annum, rising to 1.7 billion in 2029-30. So the first, we would submit, primary aim was to raise revenue. The second was that the policy should be fair, with all private schools paying their fair share. And then we say the Divisional Court recited the government's case, applying the measure across the board without any of the exemptions sought by certain lobby groups, such as small faith schools, ensures that all users of private schools pay their fair share. We, of course, strongly dispute that characterisation, and will do so by reference to the justification stage of the Article 14 analysis. We entirely accept, of course, that it is important that tax change is fair. We strongly dispute that fairness is achieved here by treating our community in the same way as other private school users. The third policy objective was that pupils with the most acute needs would not be impacted, and that meant that pupils with an education, health and care plan which named a private school would continue to attend that school with fees paid by the local authority, which would be able to reclaim VAT under existing arrangements. And the fourth principle, paragraph 22, was that the administrative burden for taxpayers should be minimised and the policy should not be open to abuse. We entirely accept that that is a legitimate aim, but we agree with the Divisional Court that only modest weight should be afforded to it here on our facts in the proportionality assessment. Paragraph 23 of the Divisional Court then considers the process by which the policy was adopted, the consultation that generated over 17,000 responses, and then the decision not to make or perhaps put forward amendments by the government was said to be because they would diminish the revenue generated and would be unfair, unworkable and or administratively onerous. So picking up essentially the first, second and fourth of the policy objectives. So that's our submissions on the second heading, my lords and my lady. I could move then to our third heading, the appellants and the community. That was addressed by the Divisional Court at paragraphs 138 to 149. For anyone following, that's 194 of the core bundle. And the main evidence was the statement of Mr. Pinter, or Hinnock UK, the main community organisation. That was what the Divisional Court started their consideration with at paragraph 139. The evidence as summarised by the Divisional Court was that the relevant group here is around 20,000 school-aged pupils across the UK who attend Haredi independent schools. These children and families are therefore a minority within a minority. The families tend to live in clusters in certain geographical areas, and the curriculum and teaching environment of the schools is closely aligned with Orthodox Jewish customs and values and promotes the Yiddish language. The Divisional Court cited an extract from Mr. Pinter's witness statement. There are 3 points that we'd seek to pick out from that extract. The first is Mr. Pinter's evidence that attending independent faith schools is a non-negotiable part of faith for the overwhelming majority of the Haredi community. The second is that there's no choice for these families to send their children to non-Haredi state schools, both due to their religious beliefs and because insufficient space is available in the state sector. And the third, at the very end of the extract, is that not a single Haredi child attends a state school outside of Haredi state schools. The court will be aware there are very few of those. So our submission is that the practical reality that arises from that evidence is that if Haredi independent schools close because of the need to charge VAT, or if families cannot afford higher fees, these children will not move to the state sector, as with other private school users. The most likely outcome, and we'll see the evidence of this, is that they will be home educated. Now, could I go briefly to the underpinning evidence, Mr. Pinter's statement, which is at page 18 of the first supplemental bundle, or the relevant parties. If I start at page 17, just above paragraph 40, Mr. Pinter's there considering the impact of
which
VAT.
page is that?
Page 17 of the first supplemental bundle.
Yep.
Great, my lord. So Mr. Pinter, just above paragraph 40, is considering the impact of VAT on Haredi independent schools and families. If we go over to paragraph 42, Mr. Pinter explains there why mainstream non-faith schools cannot accommodate essential aspects of Haredi education, such as Torah learning, Jewish holidays, daily prayers, and kosher facilities. He then emphasises that on top of this, the risk of anti-Semitic bullying for visibly Jewish children makes mainstream non-Jewish state schools impractical, and the few state-funded Haredi schools, established over a decade ago, cannot absorb an influx of thousands of displaced students.
Is any of this disputed by the respondent?
My submission, my lord, is no. And I'll show your lordship the findings of fact the divisional court made, which, although not to the extent we say perhaps they ought to have done, go very much in the direction of accepting this evidence. So we have the findings of fact, neither party in the appeal challenges them, but we say there was no challenge to the evidence either. So, my lord, we do say the divisional court didn't engage properly with Mr. Pinter's evidence as the community's experience of anti-Semitism. If we could just go back to paragraph 20 of Mr. Pinter's statement, which is at page 12 of this bundle. He gives evidence as to the community's attitude towards state education and state services being informed by its lived experience, and describes anti-Semitism, one of the oldest documented forms of hate. A particularly pervasive form of anti-Semitism was government bans around Torah study, and then says there are well-documented recent cases of Jewish students encountering deep-seated anti-Semitism in general state schools, and provides an exhibit for an example of this. This has led to mistrust of state education and concern about the ability of state school leaders to maintain their autonomy to run their institutions in a way which is consistent with their faith. And over to 21, there are a few Haredi state schools in the UK, and these schools have in recent times faced significant practical hurdles and regulatory barriers. So there's a
Is there
very...
only one, in fact?
Sorry, madam.
Did I read there's only one, in fact, Haredi state school?
In Hackney, my lord, there is one, and it's a girls' school. We'll see the evidence of that in a moment. So, my lord, if we then go back to the divisional court judgment, please, at paragraph 140, we see the vast majority, or the divisional court found, that the vast majority of Haredi children live in large, low-income families. Haredi schools ask for minimal contributions, typically less than £100 per week. In practice, children are typically not denied access if their parents cannot afford these fees. And then quoting from Mr. Pinter, as the community tends to find a way to support specific students, we of course will submit that that can only go so far.
But presumably the capital and possibly the revenue costs of just making sure these schools continue to function, that's a financial cost, presumably, that what the general community is sharing through donations and the like, is that right?
Yes, my lord. So where families are asked for contributions, but where they can't pay, as Mr. Pinter says, the community tends to find a way.
Yeah.
So donations are sought and often given so that these children can actually attend at the moment.
Because one, I'm sorry to take you
Not
out
at all,
of
my
turn,
lord.
and I don't want to take you out of turn at all, so please do come back to
Right.
this. But certainly, speaking for myself, I would like your assistance at some point on what the evidence actually amounts to, that the schools would in fact close
Yes,
because
my
of
lord.
the VAT change.
Yes, so I will. Perhaps I should take that immediately, my lord, as it's obviously a very important question. And the best answer to that is the Divisional Court at 144. The government's own internal documents show that ministers were advised that faith schools serving narrow religious communities were generally smaller schools with lower fees on average. They would face a proportionately larger net VAT liability because staff costs make up a larger proportion of their costs, and these cannot be reclaimed.
Sorry, you said 144?
Of the Divisional Court, my lord.
Oh yeah, thank you.
Great. And then importantly, they generally cater for middle income families who are more price sensitive. They would be more at risk of insolvency and will be more likely to pass on a relatively larger proportion of a new VAT charge to parents. On this basis, it was expected that pupils at these schools would be disproportionately impacted. So the government's own document showed that, and one of the documents that would support that analysis by the Divisional Court, my lords, my lady, is that in the second supplemental bundle at 535. This is within an impact assessment. It's the annex to a submission to the minister. It's described in Annex B at 533, VAT additional detail on impacts and hard cases. And so if we look down to 535, my lords, my lady, we have the heading Faith Schools.
Sorry, I must be in the wrong
The
bundle.
second of the supplemental bundles.
I've got Sup 1 and the...
Do you have supplementary bundle 2?
Which is described as reference, I think.
Reference bundle.
Yes, I've got the reference
Yeah.
bundle.
Great.
But it doesn't have 535 pages in it.
That's problematic, my lord. I'm sorry. It should extend to 1,036 pages.
Yeah, could you email it to me?
I'm not sure.
My JA will email it.
Very great.
With the extra pages.
Perhaps I can make the submission and
Yeah, no,
hopefully that won't be too
Yeah,
inconvenient
yeah.
for your lordship. In essence, we would submit that the Divisional Court faithfully reflected the government's evidence here. So if we pick up this box for those who have it, in the middle of it, the box, faith schools that serve narrow religious communities are generally smaller schools with lower fees on average, proportionately larger net VAT liability because of the staffing. And then we therefore think, right at the end, that small faith schools are more at risk of insolvency and will be more likely to pass on a relatively larger proportion of a new VAT charge to parents. On this basis, we would expect pupils in these schools to be disproportionately impacted.
That's helpful, thank you. Again, please don't take this out of turn, but flowing from that,
Yes.
I've seen a figure in the judgment and elsewhere of £30 million,
Yes.
which is the estimate in net terms, I think, of what we're talking about. If there were a low fees exemption,
That's right,
against because that's described as being net, is that based upon taking into account the fact that some parents will not in fact pay the fees because they can't afford to any longer, and or that some schools will close?
Well, may I come back to that point?
Please do.
Because I do have a note on it, but yes, I'd rather reach it in order if I may, but I will absolutely address it. And just while I have your lordship's previous point, will the schools close? There is, of course, evidence from Mr. Pinter on that as well. So it's paragraph 44 of paragraph 18 of the first supplemental bundle. So having considered why...
Paragraph
44.
44, thank you.
So the 2 points are, there is absolutely no scope to raise more money from parents. If they could afford VAT on school fees, they would already be paying the full contributions. Nor is there room to raise more from donors. If that were possible, these schools wouldn't be running at the edges of viability or on a deficit.
Well, I don't mean any disrespect at all, but of course one reads their opinion, but what I would be quite interested in is if there is more evidence in the evidence before the court.
Yes.
To support that view, because, for example, have schools closed since this was introduced last year?
My lord, I don't have instructions on that, but can I answer the point about is there more evidence? Because there is. It's paragraph 24 to 25 of Mr. Pinter, which is going to support a finding the divisional court go on to make. So this is 24 is the minimal contributions typically of less than 100 per week, and the tends to find a waypoint in terms of the community. 25 though, in general, Haredi schools are in poor financial health. They face deficits equivalent to over 3 months of operating costs, with cash reserves averaging just 3%. And Mr. Pinter has conducted an analysis of 30 of those schools out of 65, which he exhibited, showed that nearly half of them had negative net funds. Most had less than a week's worth of funds, with cash reserves averaging just half a month's operating costs.
Again, I don't want to interrupt you too much, but I understand that's the current position.
Yes.
But suppose, because the community is faced with the VAT change
Yes.
and the decision made by Parliament, at least in theory, and I'd like to test whether it's only theoretical or whether it's practically feasible,
Yeah.
at least in theory, one response would be that other people are approached to make much greater donations
Yes.
than previously
My lord,
in order to sustain the schools.
I accept that is a theoretical response. We have evidence that wasn't going to be possible. I accept it's from one community leader. But my lord, more substantively, we would submit that isn't a justification for the failure to treat this group differently, because it's not open, we submit to Parliament, to pass the burden on in this way to the community, certainly without any evidence that they are able to meet it. Perhaps I can come back to that submission when I reach Article 14. My lord, the short answer is there is, as I understand it, no more evidence before the divisional court than I've shown your lordship and your ladyship now, lordship's ladyship, and that's reflected in the divisional court judgment. So if I go back to that, go back to the divisional court judgment, we were at paragraph 140, which then hooks to paragraph 26 of Mr. Pinter and paragraph 44. So if I just look briefly again at that, if there's anything else I need to pick out. Yes. So if your lordships, your ladyship could look at the last sentence of paragraph 140, that's the finding which reflects Mr. Pinter's evidence, including his exhibit, as to the poor financial health of the schools. Deficits equivalent to 3 months of operating costs, cash reserves averaging just 3%, and of the 30 of the 65 schools considered, nearly half had negative net funds. We then have a paragraph 41, consideration of the particular position in Hackney, which is of course the largest Haredi community outside of Israel and New York, and it's where my clients live. There are over 10,000 school-age Haredi children there, which amounts to 1 in 3 children. And there's only one Haredi state school, a girls' school with 358 pupils enrolled. All the other Haredi children attend independent schools. And there were only 2,425 vacant spaces in the state sector in August of 2024. And the divisional court then referred to some of the findings of the Supreme Court in Zed and Hackney, which I'd be grateful if we could turn up. It's at tab 32 of the authorities, page 718 of the authorities bundle, for the relevant part. Sorry, that is the start of Z. The relevant part is at 729. Z was a case about housing allocation and whether or not there were discriminatory criteria being used. But in terms of the findings that the divisional court in that case and adopted by the Supreme Court made, if you look at paragraph 35 at 729, the courts had extensive evidence about the problems faced by the Orthodox Jewish community in Hackney and the need for it to gather together in Stamford Hill. And the divisional court had made a number of important findings which were not challenged. If we look over at 730, first of all at subparagraph 4, witnesses emphasised the fact that Orthodox Judaism is not a lifestyle but a way of life, and that living as a community is a central part of this. And then to 5, the Orthodox Jewish community is subjected to anti-Semitism, including racially aggravated harassment and assaults, criminal damage to property and verbal abuse. And moving forward slightly between F and G, the divisional court referred to widespread and increasing overt anti-Semitism in society and an increase in reported anti-Semitic crime, and the way in which the traditional Orthodox Jewish clothing worn by the Haredi community heightens the exposure to anti-Semitism and to related criminality. We could then go forward to paragraph 39. And another series of findings made by the Divisional Court, which were not disputed, and we say ought to be accepted here as well. The disadvantages faced by Orthodox Jews are real and substantial, connected with the religion of Orthodox Judaism. The needs of members of the Orthodox Jewish community are different from those who are not members of it. They have a relevant need to live relatively close to each other, with a view to reducing apprehension and anxiety regarding personal security, anti-Semitic abuse and crime. They also have a need for community facilities, including schools, synagogues and shops, as well as special features of accommodation, etc. And the underpinning evidence in relation to Hackney was paragraphs 29 to 32 of Mr. Pinter's first statement, at pages 14 to 15 of the supplemental bundle, first bundle. And in particular, paragraph 32 of that statement flags, this is not a point that's recorded in the Divisional Court judgment, that there are, or as of 2021, there was 1,421 children above capacity in the independent Orthodox Jewish schools at that time. So there's a very significant capacity issue, even with the independent sector in Hackney at present, before any impact of the tax change in relation to VAT. Divisional Court then pleads at paragraph 142, looking at the circumstances of my clients, as well as the other very Jewish claimant family at the time. And the Divisional Court set out those circumstances in paragraphs 6 to 9 of the annex, referring, which included reference to the concerns as to anti-Semitism. Paragraph 143 of the Divisional Court then referred to evidence from Hackney's Director of Education. And importantly, we submit, the Director of Education for the relevant borough made exactly the distinguishing point that we make, which is that while other parents might respond to increased fees by sending their children to a less expensive private school or to a state school, Haredi parents might opt for home education, which would mean that the local authority had less oversight over their education. That letter is at page 40 of the first supplemental bundle, if we can turn that up briefly. Oh, sorry, it's not. I'll find the reference, my lord, my lady, and come back to that if I may, to avoid any delay. But could I go to the second supplemental bundle at page 436, please? This is the government's own documentation, a slide from the Treasury from October 2024. And in the box, the second box of this slide, some schools serve niche faith communities and niche non-faith communities. There is a recognition in the second bullet point, risk of increased home education. And then while fees are often low cost, some communities, e.g. Orthodox Jewish, have large families, so more likely funding more children at once. So this risk, as identified by the local authority, has also been accepted by the government party. The letter is at page 40 of this bundle, my lords, my lady. And again, we simply submit that the Divisional Court has accurately and faithfully...
I'm so sorry, which page was
Not at all, on page 40 of the second supplement. This was written at the time of the technical consultation on the proposals, the general letter to whom it may concern, and the director in the middle of the paragraph expressing concern that introducing VAT coupled with the removal of charitable rates may force some of the Haredi independent schools to close, and that the consequence of that might increase the rate of parents registering their pupils for elective home education, which means the local authority has less oversight of their education. So a very particular and different consequence in our case than in other cases that are affected by
One understands that, obviously, but the legal position is that parents are entitled to educate their children at home.
Yes, my lord.
And if they don't in fact receive any education, for example, then there are appropriate steps that state authorities can take.
There are.
So in a free and democratic society, what is ultimately the problem with this?
My lord, firstly, we entirely accept what your lordship has just said in terms of the positions to home education. Why is that relevant here? We say one of the major planks of the government's justification is the policy objective of providing a generally available state school system, which is pluralistic and available to all pupils. And what we say matters here is that the Divisional Court hasn't given any sufficient weight to the fact, the evidence, that in practice this community will not take up state education. And so we say, on the particular facts of this case, that it was wrong for the Divisional Court and that this court ought to correct that error in finding that the pluralism aim is a justification for not treating this group differently.
Is it simply will not take up? That implies a choice. As I understand
Yes.
the point being made, the point really is that consistent with the beliefs of the community, they could not take up
Absolutely, my lord.
places.
And that's the
in
finding in
states.
paragraph 149 of the Divisional Court, that it's not religiously acceptable to them, which we place significant weight on. So yes, respectfully, my lady. So, my lords, my lady, that's the position in Hackney, circumstances of my client. We've looked at paragraph 144 of the Divisional Court in relation to the government documents and the underpinning impact assessment. The Divisional Court then at paragraph 145 did look at the evidence as to the potential to exempt small schools where the fees do not exceed the average per pupil funding, and reference the fact that in Victoria, Australia, a similar approach had been taken. And that's, my lord, where the evidence is that the government's analysis is that only 200 schools would be covered by such an exemption, and on a worst case scenario, this would cost 30 million, a very small proportion of the total revenue which the challenge measure is expected to raise. And in terms of the underpinning evidence for that, first statement was Peters, which is page 192 of the first supplemental bundle. Paragraph 48. You see there that the implications of a carve-out for schools below a set fee threshold, including but not limited to low-cost based schools, and costings of the loss of revenue from such an option, together with the estimated impacts on the number of pupils that will be excluded and the number of schools that will be excluded, have been undertaken. And adopting an annual fee threshold of 7,690, which is the state funding equivalent. The estimate was that some 250 schools would be carved out of the VAT policy, with an estimated 50,000 pupils, and at an annual Exchequer cost of £30 million. This was an indicative costing based on a sample of schools, estimated by modelling the fee income of schools with fees under this threshold, by multiplying our estimate of their average fees, numbers of pupils, and then the ratio of net yield to fees in the main costing of 12.4% was then applied, which gives a yield of 26 million. And then a small upward adjustment to allow for a behavioural response of schools with fees slightly above the threshold, reducing their fees in order to benefit from the relief. A growth adjustment was made, and that took it to the £30 million. So it's a good estimate, my lord, but nothing more than that. And of course, it's for all the schools, which is more than just the Haredi schools, although the Haredi schools would be a very substantial majority of that, it would appear, given the numbers involved.
Yes, again, can I just flag this, and it may be something Sir James or others will return to on the side of the respondent, but certainly speaking for myself, if there is any evidence, and there may not be, if there's any more detailed evidence as to how the 30 million was calculated, and in particular, whether it takes into account some kind of assumption, I know it's got to be an estimate, but some kind of assumption that actually some parents will not be able to pay the increased fees, given what we know about the socio-economic context we're talking about. That's why we're talking about no fee exemption at all. So some people won't be able to afford it. Therefore, you won't, by definition, you won't get any VAT on those fees because those fees will no longer be paid. But secondly, whether any kind of assumption has been made in this calculation that some schools will close. Because if the schools close, they won't be charging fees, and again, the government won't get the VAT on them.
Great, well, we will certainly look at that. My current understanding is we don't have any more evidence, but we will check.
Was there any evidence before the Divisional Court of other groups like Muslim groups and other religious groups where low-fee schools were in a similar position to the Haredi community?
Yes, my lord, there was, and directly after the consideration of the Article 14 claim for the Haredi community is consideration of the Article 14 claim for the Muslim community, for example. Right. Essentially, put very broadly, my lord, there was significantly more evidence in relation to the Haredi community than in relation to the other communities, and I can show your lordship that, if I may, when I get to that point.
I think it would just be useful for us to know, probably none of us have experience of these schools in the different communities that live in London and other towns in our cities. And it would just be useful for us to have some sort of overview of what we're talking about.
Yes, ma'am.
Beyond the Haredi community.
Yes. We will certainly see if we can find anything that was before the Divisional Court, my lord, in that respect. The evidence, as I say, is that the community in Hackney is very substantial, over 10,000 school-age children.
No, I completely understand.
So therefore they are a substantial majority, or a significant majority, but I need to check if we have anything better than that to assist your lordship.
Thank you.
So then if we go back to the Divisional Court, my lord's lady, we are at 145. And we've looked at the consideration of the exemption there, and then the headline submission for my clients summarised at 146. The submissions for the government summarised at 147 to 148. And in particular, we say it's 148 that is highly relevant to your lordships and your ladyship, because that's the relevant exception, which is the low fee exception, which all parties focused on. And the problems put forward by Ms Hannett, Ms Counsel, on behalf of the government were said to be, first of all, that it was unfair, and secondly, that it was, first of all, that it was open to abuse and administratively unworkable, and also that it was said to be unfair because state schools are able to educate children of all faiths and none through systems of mutual tolerance and respect. And we say, essentially, that a major question for your lordships and your ladyship is whether the government has established that that policy aim effectively trumps the position of my clients and provides the justification that the government needs to have for not treating them differently. It's also said, and of course this isn't contested, that in principle the state is not required to subsidise private education because some religious communities do not wish to avail themselves of pluralistic teaching, or indeed for any reason. We say again that doesn't answer the question, the key question here, which is, can you justify not treating this group differently in the particular facts of their case? So then we have what we submitted the key findings of the Divisional Court at paragraph 149 under the heading of discussion. And there are three. First of all, that Haredi Jewish families have a strong religious and cultural preference.
Sorry, where are you now?
Just over at 149 in the Divisional Court. So the evidence establishes three material features of the circumstances of most.
I'm sorry to, before we just go on to this, you said the policy aim, the key question
yes.
is, can you justify not treating this group differently? But of course, if you were going to treat this group differently, you would have to justify treating only this group differently. What are you proposing? What are you contending for? do you contend for a low fee exemption across the board, as the divisional court
Yes.
thought was the only sort of plausible option, or do you contend for treating the Haredi community specifically?
So, my lord, we say the question for this court in the first instance is, has the government justified not treating this community differently for the purposes of Article 14 criminal discrimination? We accept that as part of that, the government's entitled to say, and this court's entitled to ask, well, how would we treat them differently? Because there has to be a practical way of doing it. And we concur with the divisional court's finding that the most plausible way of doing it is through the low fee exception. But we don't, strictly speaking, my lords, my ladies, say the failure to make the low fee exception is what results in the breach of Article 14. What we're seeking is a declaration of incompatibility on the basis that there has been a failure to treat our group differently without objective and reasonable justification. How that is then remedied, of course, is a matter for Parliament. We would expect that the first thing that would be considered is the low fee exemption, but it's not for us to dictate the method of remedying the breach. So, of course, the focus was necessarily on the low fee exception. That was what was being put forward as the practical measure.
So you say we don't have to be, ultimately, we may be interested
Yes.
in, we may ask you questions, but you say we don't have to be concerned with the question of whether others are in the same position or whether there could or could not have been evidence as to other communities.
That's right, my lord.
Once we answer the question that whether it can be justified in not treating this group differently,
Yes.
a declaration of incompatibility follows, and it's a matter for Parliament.
That's precisely what we say, my lord. And I would go one stage further, but my lord may have a question.
Forgive me, I
Not
didn't.
at all.
I just wanted to be clear that so far as Article 14 grounds are concerned,
Yes.
how do you define the status that you're relying on? Is it being Jewish or is it being member of the Haredi community?
Haredi Judaism, my lord, yes. And that's that constellation of race and religion, being a minority within a minority. Absolutely. And if I may just go one stage further on the point that where I respectfully agreed with Master of the Rolls. We say that what matters is, can the government justify not treating our community differently now? Because, of course, we say it's a fresh assessment case following Svidler. It's not a case that you would have to find in principle that there could never be a justification. What matters is, on the evidence before this court now, or before the divisional court if I'm wrong about the fresh assessment, was there evidence such that the failure to treat us differently was justified? And that's what the court would be declaring. So it's possible, of course, that ultimately efforts were made to remedy the breach and it's not possible, it's not practicable, and that would be a new set of facts. But the evidence, the burden is clearly on the state at this stage to justify the failure to treat us differently, which I will show your lordships, your ladyship, I hope, in just a moment.
Can I just go back to
Yes.
the fact that you say the focus is on the not treating differently,
yes.
rather than on, say, the low cost exemption?
Yes.
But can you really draw a bright line distinction? Because in deciding whether, if there is discrimination, deciding whether it can be justified, you're looking at the reasons
Yes.
for not
I
We're
agree.
not drawing a distinction, and those are centred around, what you've taken us to, are all centred around the low cost exemption. So I'm finding the bright line
Yes.
distinction rather difficult.
Respectfully, my lady, I agree. I don't say there's a bright line between the two. But I do say that it's important that the court asks itself the right question, which is it justified, were the government, state justified in not treating us differently? As part of that question, part of answering that question, you will, of course, look at, well, how would you have treated us differently? Is that practical? Is that effective? Does it have other negative consequences? And that's where the low fee exemption evidence comes in. But it is important in our submission not to simply ask, was the government right? Were they justified in not making a low fee exemption? That would be the court going too far, respectfully, in terms of determining how any failure to treat us differently ought to be resolved.
Well, can I maybe put the question another way? I don't
Yes.
understand you to be putting forward anything apart from the low cost exemption as a means that we should be thinking about.
My lady, we remain of the position that we put forward in divisional court, or that Mr. Luckhurst put forward. There was, of course, at 152 of the divisional court, a submission that an exemption could be narrowly drawn by reference solely to hereditary Jewish schools. And two answers were given as to why that exemption would be justified, that hereditary Jews have a particular need for an education with special religious and cultural elements. But the divisional court was unpersuaded by that because there may well be other claims, others with justifiable claims. And essentially, we don't have the evidence to say that we are the only group in this position. And so we don't demur from the finding in paragraph 154 that the most plausible suggestion is the low fee exemption. But we are here to talk about the position of our community, my individual clients and the community they are part of, and we say we ought to have been treated differently, probably by making the low fee exemption. I hope that provides some assistance, my lady, because we accept entirely that there is a close relationship here, but we do seek to focus on what the proper question must be, which is, is there justification for not treating us differently in any way? So we were then just looking briefly at the actual findings that the divisional court made at 149, and they are obviously of significant importance, and no party seeks to persuade your lordships and your ladyship to depart from them. The second is, of course, the one we focus on. Secondly, there are almost no state schools which offer a hereditary education. So they, as in the community, do not have state alternatives which are religiously acceptable to them. And that's my lady's point, respectfully, that if this is a choice, it's a choice which is highly fettered, because to choose a state school in Hackney means choosing a school which is not religiously acceptable. And we respectfully adopt and endorse that finding. And then thirdly, uncontroversially, the community form a socio-economically deprived community and often have large families. And that then led to uncontested findings that are of importance here, that the challenge measure, i.e. sections 47 to 49 of the Finance Act, fails to treat differently groups whose situations are significantly different, and thus that its uniform nature requires justification under the Fluminos principle, and that it has disproportionately adverse effects on hereditary Jews, a group defined by a common race and religion, and thus the measure is indirectly discriminatory and so requires justification. We focus on the Fluminos lens. So that was what I wanted to say about the evidence, my lords, my lady, and the findings the Divisional Court has made. Fourth heading then of Article 14 and the proper approach to proportionality. That takes us back in the Divisional Court judgment to paragraph 122. And in essence, the Divisional Court here has summarised and adopted the very extensive analysis by the Supreme Court in the case of SC, the two-child limit case, which I'm going to take us to in a moment, if I may. We see the reference to two preliminary matters at paragraph 123, the first being ambit, that the alleged discrimination falls in the ambit of one of the substantive articles, the second, that the discrimination is on one of the grounds expressly referred to or on an other status. Both those hurdles were surmounted here.
Now, the expressed ground is religion, is it?
Yes, my lord. Well, we would say religion and race, because hereditary Judaism is a constellation of the two. Both suspect grounds, of course. Which we'll
Well, you say that, but actually, when I asked you a similar question a few minutes ago, you said it's not being Jewish, it's being a member of the Haredi community.
Yes, which is itself, we would respectfully submit, a religious identity.
And racial identity.
And a racial identity, yes. So, ambit and status were uncontroversial. Once these hurdles are surmounted at 124, the prohibition in Article 14 encompasses three distinct species of discrimination. The first, direct discrimination, a difference in the treatment of persons in analogous or relevantly similar situations. Secondly, flimenos discrimination, failing to treat differently persons whose situations are significantly different. And thirdly, indirect discrimination, a measure or policy based on an apparently neutral ground, which in practice causes a disproportionately prejudicial effect. If we could then go to SC to look at the analysis of, in particular, of justification, but could we start, please, with paragraph 33, which is at page 788 of the authorities. And of course, this is a unanimous decision of a 7-member Supreme Court. Paragraph 37 of SC at 788, citing Castle in the UK in the Grand Chamber for the general approach to Article 14. We take the reference to status, and then paragraph 3, such difference of treatment is discriminatory if it has no objective and reasonable justification. In other words, if it does not pursue a legitimate aim, or if there is not a reasonable proportionality between the means employed and the aim sought to be realised.
Can I just ask you to pause for a moment there, if you don't mind? I may be wrong, but my reading of SC is that the Supreme Court expresses the test for justification precisely in the language you've just shown us, a reasonable relationship of proportionality between means and aim. Correct me if I'm wrong. They don't deploy the well-known Bank-Mellett formula.
That's right, my lord. Certainly the general considerations are said to be the Carson considerations, not the Bank-Mellett considerations. Yeah. What I would submit is that in considering the reasonable relation of proportionality, the Bank-Mellett stages of proportionality are therefore invoked. So you can still and should still look at least intrusive means and fair balance in particular.
Yeah. So is it your submission that it's implicit within the test, even if it's not expressed?
Yes, my lord.
And you do invite us to carry out the 4-stage Bank-Mellett test?
We do, with particular reference to stages 3 and 4. And then, my lords, my lady, Carson, of course, recognises the concept of the margin of appreciation in Strasbourg, which has its domestic analogue, as we see, and recognises that the scope of this margin will vary according to the circumstances, the subject matter, and the background. And that's the nuanced approach that Lord Reid then goes on to describe. We then go on to paragraph 99. Well, actually, my lords and my lady, on the way, 48 of SC has the Flimenos principle summarised, and the summary that's given in the 4th line is that Article 14 may impose a positive duty to treat individuals differently in certain situations, and then referencing Flimenos. We then go forward, please, to paragraph 99. Which we have at page 804 of the bundle. And this is the start of a lengthy analysis of the approach of the European Court to the test of justification, which we see at 98 being summarised. 99, the Court has not itself provided in its judgments a systematic analysis of relevant factors or an explanation of how they interact. Its accounts of the general principles applies are stated at a high level of generality. Nevertheless, patterns emerge and inferences can be drawn. It is doubtful whether the nuanced nature of the approach which it follows can be comprehensively described by any general rule. It's more useful to think of there being a range of factors which tend to heighten or lower the intensity of review. In any given case, a number of these factors may be present, possibly pulling in different directions, and the Court has to take them all into account. The case law indicates, however, that some factors have greater weight than others. And at 100, one particularly important factor is the ground of the difference in treatment. We would say, of course, equally the failure to treat differently. In principle, and all other things being equal, the Court usually applies a strict review to the reasons advanced in justification of a difference in treatment based on what is sometimes called suspect grounds of discrimination. 101, reference.
Could you read to the end of paragraph 100, please?
These grounds form a somewhat inexact category, which has developed in the case law over time. Capable of further development. Furthermore, a much less intense review may be applied even in relation to some so-called suspect grounds, where other factors are present which render a strict approach inappropriate, as some of the cases we discussed will demonstrate. We of course, entirely accept that. The court originally developed a requirement that very weighty reasons must be shown to justify a difference in treatment based on sex or gender, 101, and some analysis of the early cases. And then at 103, the case illustrates 3 points of wider significance. The first is that the court's statements that very weighty reasons are required to justify a difference in treatment on a particular ground do not necessarily exclude the possibility that a relatively wide margin of appreciation and a correspondingly less intense standard of review may nevertheless be appropriate in particular circumstances, the example of historical inequalities being correct. Second is the court's case law evolves in the light of the development of common standards, and the third, importantly for our purposes, is that the court has moved over time towards explaining the need for weighty reasons to justify certain grounds of difference in treatment in terms of the link between those grounds and problems of stereotyping, stigma, and social exclusion which prevent participation in society on an equal footing to others. And we say that that is directly where our facts fit. We then move forward to 108, 109, my lords. We have the reference to the strict approach, my lords and lady, to the strict approach to differential treatment on the grounds of race or ethnic origin. And then at 109, strict approach also to differences in treatments on ground of religious belief in the light of the importance of the right enshrined in Article 9 in guaranteeing the individual's self-fulfillment. And then at the bottom of that paragraph, similar to that applied in the context of difference in treatment in the more original suspect grounds. But then at 110, a less strict approach in some cases concerned with discrimination on the ground of religious belief where other factors were relevant, referencing Ouida and the United Kingdom, which are around manifestation of religious belief, not, we say, going to be a relevant factor in this case. 112 then references the disability approach, reference to Glor and Guberina. And although, of course, this isn't a case about disability, we do rely on what is said in Guberina in the indented paragraph between G and H, so that the reason for the strict approach in the disability context is that such groups were historically subject to prejudice with lasting consequences, resulting in their social exclusion. Such prejudice could entail legislative stereotyping, which prohibits the individualized evaluation of their capacities and needs. We say again, that's directly on point here, that it's not enough to just say no exceptions for faith groups. The particular circumstances of this community need to be properly taken into account. We then have at 115 the summary of the Strasbourg Court's approach to justification. Describes the matter of some complexity as a number of factors affecting the width of the margin of appreciation can arise from the circumstances, the subject matter and its background. We rely in particular on 2. Very weighty reasons must be shown, but a wide margin of appreciation is usually allowed to the state when it comes to general measures of economic or social strategy. So that's the balance, and we say this is a case where the competing factors do pull in opposite directions. Over at 3, common standards, we don't seek to invite your lordships, your ladyship, to make any particular finding about that on the facts of this case. We accept what the divisional court said, but it provides neither side much assistance here. And then 5, a wide variety of other factors may bear, highlighting again the nuanced approach that needs to be taken. And at 116, unless one factor is of overriding significance necessary for the court to make a balanced overall assessment. And then by reference to the Grand Chamber's judgment in Steg, concerning a difference in treatment on the ground of sex in relation to entitlement to a state benefit, this is 117. At 118, the indented paragraph, the scope of this margin will vary according to the circumstances, the subject matter, and the background. Again. And that takes us to 120, where Lord Reed said that Steck illustrates how, where a ground of differential treatment is one which could generally be justified only by very weighty reasons, other factors may nevertheless make it appropriate to allow the state a wide margin of appreciation. It also demonstrates, we say importantly for our purposes, but the fact that the case falls within the general scope of the manifestly without reasonable foundation approach is not the whole story, where other relevant factors are also present. Moving on then to 129, if I may, at 813 in the bundle. Another summary of the case law from Steck onwards, again emphasising the court has consistently differentiated at 1 between cases where suspect and suspect grounds have been an issue, and at 2, the court has almost always recognised the general appropriateness of a wide margin in relation to general measures of economic or social strategy, reflected in the context of welfare benefits, pensions and social housing by the manifestly without reasonable foundation formulation. And then at 130, towards the end of that paragraph, just above G, it appears therefore that in cases involving suspect grounds in the field of welfare benefits and pensions, the determinative factor has generally been whether very weighty reasons have been shown, but the court has taken account of the wide margin generally applicable in that field when making that assessment. So Lord Reid, finding that the very weighty reasons test is applicable while taking account of there generally being a wide margin of appreciation in that context, we say is analogous to the context here. Then we have the discussion of JD, and recognising at 132 that this was an application of the Claimants approach to discrimination just between B and C. And again, it's consistent in our submission with the approach that Lord Reid is summarising. And in particular, the finding after the indented paragraphs from JD, Lord Reid says just above 134, letter B on page 815, the court considered, Strasbourg Court considered, that very weighty reasons were required to justify the impugned measure in respect of the applicants. Now that, Lord Reid said, required significant care and careful scrutiny at 134, and essentially the applicants were wrong to suggest that that ousted the manifestly without reasonable foundation test or the width of the margin of appreciation. And the conclusion of that analysis, which is what we need, is at 142, where Lord Reid says, in summary, the European Court has generally adopted a nuanced approach, which can be understood as applying certain general principles, but which enables account to be taken of a range of factors which may be relevant in particular circumstances, so that a balanced overall assessment can be reached. No mechanical rule that the judgment of the domestic authorities will be respected unless it's manifestly without reasonable foundation. The general principle that the national authorities enjoy a wide measure of appreciation in the field of welfare benefits and pensions forms an important element of the court's approach, but its application to particular facts can be greatly affected by other principles, which may also be relevant, and of course by the facts of the particular case.
So you're at 142?
142, my lord.
Yeah, and do you emphasise the final 5 or 6 lines?
It precisely. The fact that a difference in treatment is based on the suspect ground is particularly significant, by reference to the recent cases. So then how is that translated across to the domestic court? That's 143 onwards, identifying the analogous approach to the margin of appreciation. And in particular, we emphasise 144. The second reason for that analogous approach is that domestic courts have to respect the separation of powers between the judiciary and the elected branches of government. They therefore have to accord appropriate respect to choices made in the fields of social and economic policy by the government of Parliament, while at the same time providing a safeguard against unjustifiable discrimination. Reference Lord Neuberger in RJM. There will come a point where the justification for a policy is so weak or the line has been drawn in such an arbitrary position that even with the broad margin, the court will conclude the policy is unjustifiable. Again, we emphasise here that we do not mount any attack at this stage on the overall policy. It's about failure to treat us differently. So 145, in domestic law as at the Strasbourg level, one would expect closer scrutiny where the case concerns discrimination on a suspect ground. Distinctions drawn on suspect grounds are inherently appropriate for close judicial scrutiny, notwithstanding the respect due to the judgment of the executive or legislature. And then 147, approval of what was said by Lord Nichols in the early case of Guyden and Godin Mendoza, over at page 819, Parliament is charged with the primary responsibility for deciding the best way of dealing with social problems. National housing policy was a field where the court would be less ready to intervene, since Parliament had to take into account broad issues of social and economic policy. Nevertheless, he said, even in such a field where the alleged violation comprises differential treatment based on grounds such as race and sex or sexual orientation, the court will scrutinise with intensity any reasons said to constitute justification.
Forgive me for interrupting.
Got
Does the case law give us any guidance on this issue of intensity of review?
Yes.
In direct discrimination cases as opposed to flimenos or indirect cases?
Lord Reed and SC doesn't make anything of the distinction between direct or indirect. But there is a run of cases, of course, my lord, which recognises that.
Thank you.
Not distinguishing between indirect and flimenos. So essentially we say that flimenos...
As I read the judgment of the Divisional Court in the present case, I thought it was quite interesting that actually, the way I read that, is that they thought that flimenos was closer to the direct end rather than the indirect end.
Yes, my lord. In terms of what has to be justified, that was what they said. And we agree that that's correct in terms of what has to be justified. But in terms of the margin and the approach that's taken to standard of justification, we would accept that the flimenos is a species of indirect discrimination. So, my lord, 149, then there's discussion of Humphreys, which was seen to potentially change the picture. And the answer, in short, was that it didn't. Lady Howe had said that careful scrutiny was needed in that case. That was convention compliant. And that's paragraph 153. And so we get the overall conclusions, my lords, my lady, at 157. And in particular, at 158, it is appropriate that the approach which this court has adopted since Humphrey should be modified in order to reflect the nuanced nature of the judgment which is required following the jurisprudence of the European Court. In the light of that jurisprudence as it currently stands, it remains the position that a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of socio-economic policy in the field of worker benefits and pensions, so that the judgment of the executive or legislature will generally be respected unless it's manifestly without reasonable foundation. Nevertheless, the intensity of the court's scrutiny can be influenced by a variety of factors, and in particular between A and B, very weighty reasons will usually have to be shown, and the intensity of review will usually be correspondingly high if a difference in treatment on a suspect ground is to be justified. And that's an indirect discrimination analysis.
Is that right?
Well, yes, my lord, because it's the modification of the Humphreys approach, and Humphreys is an indirect discrimination case.
I see.
And of course, SC, most importantly, was an indirect discrimination case. That's what they were considering, is whether the rule indirectly discriminated against women and children, put shortly. So we say absolutely we are within that territory of very weighty reasons being needed and a correspondingly high intensity review, because the failure to treat us differently is on a suspect ground. And 159, emphasising no mechanical approach, a more flexible approach will give appropriate respect to the assessment of democratically accountable institutions, but will also take appropriate account of such other factors that may be relevant. And then at the end of that sentence, citing Guyden and RJM, as a general rule, differential treatment on grounds such as sex or race nevertheless requires a cogent justification. And so at 161, focus domestically, the more fruitful focus should be on the question whether a wide margin of judgment is appropriate in the light of the circumstances of the case. And then 162, important to bear in mind that almost any legislation is capable of challenge under Article 14, and referencing that there ought to be careful consideration of the risk that of undue influence by the courts in the sphere of political choices. That's just below C. And we accept that, of course, my lords, my lady, but we still very much say that Parliament in this case has to provide cogent justification for not treating us differently, or there has to be cogent justification for Parliament's failure to treat us differently, notwithstanding the risk that's identified in 162 and the general width of the margin in a case such as this. Can I look at one further case pleased with your lordships and your ladyship on the proper approach, which is guberina, which we have in the authorities at tab 58, page, and I'm looking in particular at page 1864. So guberina is a tax case, and the Strasbourg court here at 73 says, on the one hand, wide margin is usually allowed to the state under the convention when it comes to general measures of economic or social strategy. 73, 1864. This also includes measures in the area of taxation, so we accept there's no meaningful distinction that we are within the area of taxation. However, any such measures must be implemented in a non-discriminatory manner and comply with the requirements of proportionality. On the other hand, if a restriction on fundamental rights applies to a particularly vulnerable group in society that has suffered considerable discrimination in the past, then the state's margin of appreciation is substantially narrower, over the page, and it must have very weighty reasons for the restrictions in question. The reason for this approach is that such groups were historically subject to prejudice with lasting consequences resulting in their social exclusion. Such prejudice could entail legislative stereotyping, which prohibits the individualised evaluation of their capacities and needs. And we say we are directly within that formulation.
Is this principle being set out in the context of direct discrimination or indirect?
Indirect, my lord. So we say this is a case, again, very totally consistent with Lord Reed's approach in SC, of course, as it must be, where the margin is substantially narrower because of the particular context of our case. And then finally on the case law, if I may, a case relied upon by the government parties in their skeleton at paragraph 37 is Ellen Kane, and that's at tab 34 of the authorities, paragraph 55, page 858. And what the government rely on is the margin of appreciation is a concept of particular significance in relation to positive obligations. This is because the imposition of such obligations requires contracting states to modify their laws and practices, and possibly, as in the present case, to incur public expenditure in order to advance social policies which they may not wholly support, etc. And then, while not being a conclusive objection, those characteristics of positive obligations indicate the importance of exercising caution before they are imposed, and that's then referenced as the margin of appreciation at 56. The width of the margin of appreciation varies according to the circumstances. But we say that that's a misdirection by the government, because this is about positive obligations in the Article 8 context, not about the thlimenos aspect of discrimination contrary to Article 14. And we say that matters, and I'll explain why in a moment. And the first sign that this is a different kind of case is paragraph 56, because the factors that are identified here are different to the factors that Lord Reed identifies in SC. Two particularly important factors are, first, whether a particularly important facet of an individual's existence or identity is at stake, and secondly, whether there is a consensus within the member states of the Council of Europe.
So which paragraph?
56, my lord. So the two particularly important factors are not the factors, or not analogous with the factors that Lord Reed has identified in SC. And the reason for this, if we go back to paragraphs 30 to 31, we see that what was being contended for in Ellen Kane was Article 8 imposing a positive obligation upon the Secretary of State at 31 to provide the appellant with an ex-passport in order to secure the appellant's right to respect for private life. And the question was whether it was a positive obligation or an unjustified interference with the right to such respect. The courts below favoured the former analysis, and the authorities support that approach. At 32, the European Court has generally analysed cases concerned with gender identity from the perspective of whether the respondent state has failed to comply with its positive obligation to secure to the persons concerned their right to respect for private life under Article 8. And it's well known in my submission, my lords and my lady, that the threshold for establishing such a positive obligation is very high. And part of the reason for that is what's summarised by Lord Reed at paragraph 55, which is the positive obligations involve incurring public expenditure in order to advance social policies which they may not wholly support, etc. That's not the analysis in Article 14. So Ellen Kane, we say, is of no assistance to your lordships and your ladyship. The approach that has to be taken in an Article 14 Claimants case is the same as in an indirect discrimination case, as set out comprehensively by Lord Reed in SC. So unless I can assist further on SC or the background case law, I would go back to the divisional court, if I may, and look at what was said about justification, starting in particular at 128, paragraph 128 of the divisional court. You see the divisional court correctly identified themselves with respect that if a claimant can establish that he or she has been subject to any kind of discrimination, the burden shifts to the state to establish justification. The question of what exactly it is that must be justified is not entirely straightforward. Citing SG, Lady Hale said that in a direct discrimination case, it was the differential treatment that had to be justified, whereas in an indirect discrimination case, the measure was ex hypotheosi neutral, so what had to be justified was the measure itself. That's consistent with the language used in SC at 53. However, 129, in our judgment, however, Claimants discrimination has more in common with direct discrimination in this respect, and that's why we respectfully say the divisional court was right. It's only in this respect. If the thing that must be justified in a direct discrimination case is the differential treatment, logic would suggest that in a Claimants discrimination case, what must be justified is the lack of differential treatment. But we say that that becomes very similar in practice to the indirect discrimination analysis, because it's the uniform nature of the rule or the absence of exemptions rather than the policy in some broader sense. So we say that there's no real difference in outcome here, certainly, as to whether it's the indirect discrimination question that's asked or what the divisional court held to be the particular question in a Claimants case. But we say that the divisional court was right, that in Claimants the key question is whether the lack of differential treatment has been justified. My lords, my lady, it may be helpful just to look briefly at SG, which is in the bundle at 509, on this point about whether there is a real difference with indirect discrimination. So it's page 509 of the authorities, paragraphs 188 to 189, the benefit cap case. And this is where Lady Hale sets out the difference between direct and indirect discrimination justification approaches, saying between G and H, it's not the scheme as a whole which has to be justified, but it's the discriminatory effect. It's not enough for the government to explain why they brought in a benefit cap scheme that can be readily understood. They have to explain why they brought in the scheme in a way which is disproportionately adverse effects on women. And then over at 189, however, it is important to understand that what is needed to justify indirect discrimination is different from what is needed to justify direct discrimination. In direct discrimination, it's necessary to justify treating women differently from men. In indirect discrimination, by definition, women and men are treated in the same way. The measure in question is neutral on its face, not necessarily targeted at women or intended to treat them less favourably. Men also suffer from it. But women are disproportionately affected. So between B and C, it is therefore the measure itself which has to be justified, rather than the fact that women are disproportionately affected by it. But it is, of course, still the discriminatory effect of the measure that has to be justified. We've got that at 188. It's the first of the points that Lady Hale derives from STEC. And so that's why I say, my lords and my lady, that the outcome would be the same, whether you applied the indirect discrimination lens or the Claimants lens as the divisional court found it. What you're needing to justify in the indirect discrimination approach per SG is applying the measure in a uniform way, which has a discriminatory effect on my clients and their community. So it may be a distinction without a difference, but we say in any event the divisional court were right to focus on the failure to treat differently. So that's the approach, the question, if you like. At 130, the divisional court then consider the breadth of the margin, rather than the margin of discretion. We would respectfully say the margin of judgment. And the factors that have been mentioned previously under A2P1 will be relevant, as will the question whether the discrimination is on a suspect ground. So there was a recognition by the divisional court that the suspect ground point was relevant. But a less intense level of review may be appropriate where the discrimination complained of is indirect, even involving a suspect ground. Well, we say that that has to be read as meaning that an intense level of review may be appropriate in an indirect case versus a direct case. So not that it may be appropriate within indirect discrimination cases because they are indirect discrimination cases. That would be contrary to the very clear guidance in SC. So to the extent that the Divisional Court were relying on anything said in Motherhood Plan to mean that the margin should be lesser here, we say that's wrong, other than less than if it were direct discrimination. And then the Divisional Court cited SC at 162 and quoted that passage in full. And of course, we accept what Lord Reed said at 162, but we respectfully demur from the suggestion that that is the ratio of SC or the most important principle to be derived from it. The most important principle to be derived from SC in our respectful submission is that a nuanced approach balancing all the relevant factors is required. And per para 157, very weighty reasons will usually have to be shown in a suspect grounds case. And so that's why we say the Divisional Court hasn't fully understood the importance of the fact that our case was very clearly about suspect grounds discrimination. Para 131, the Divisional Court then looks at bright lines rule concept. We say in relation to bright line rules that of course they're justified in principle, but again they're not relevant to the assessment that has to be carried out here because we've established already that we are in a significantly different position. And so what has to be justified is not treating us differently. And to say, well, we're not treating you differently because we have a bright line rule, in our submission is circular.
Well, it's not with respect as simple as that, is it? If you are asked to carve out an exemption for one group of people in society, and you look at that and you conclude, having weighed a number of factors in the balance,
Yes.
that actually we can't properly and defensively carve out that exception, don't you end up with a bright line rule?
A justification of a resulting justification of the bright line rule. Yes, my lord, you do. But where we say the Divisional Court erred was by applying the principle, this is the end of paragraph 133, that it may in principle be justifiable for a legislature to prefer a general rule with no exceptions over a system which requires fine and potentially invidious distinctions between categories of individuals who qualify for an exemption and categories who do not. As if that answers the question. Because what needs to be answered here is, well, does the creation of the exemption unacceptably undermine the policy intention? Is it so administratively unworkable as to mean that the bright line rule is justified?
But who's to decide these sorts of nuanced questions?
Yeah.
Like, for example, unacceptably
Yes.
undermines the policy objectives.
Yes.
Suppose the evidence demonstrated that it's not 30 million that you'll lose out, but it's only 20 million.
Yes, my lord.
Is that the kind of judgment that this court can or should be making? Or if you, say, take the design of the system,
Yes.
if they take the view that in order to get even that 30 million in, we're going to have to spend, I don't know how much, we're going
Yes.
to have to spend 1 million,
Yes.
10 million, in order to create an administrative system to prevent abuse, for example,
Yes.
to check, monitor everything is being done according to the rules which govern the carve-out. Again, who's to make that judgment?
The court is, my lord. Respect. The court is, my lord, and the reason for that is the court is the ultimate safeguard against discrimination.
Well, I appreciate we're the ultimate safeguard, but aren't we entitled to, and perhaps required to, give a certain latitude of judgment to the
Absolutely, my lord.
to the legislature and the executive, because we're not well suited.
Institutionally
We're not
competent.
used to deciding.
Absolutely, my lord. And that's why I spent so much time on looking at what the guidance is in SC as to the margin of appreciation and what margin ought you to give to the government here. And our answer ultimately is you ought to give effectively a moderate margin of appreciation, because there are two very important countervailing factors. One is this is incredibly high socioeconomic policy, and the other is that this is an incredibly disadvantaged and vulnerable community. We have a very narrow and very particular cause, we say, that needed to be considered. And it is ultimately for the court to make that assessment, taking into account all the evidence. And again, asking the critical question, we say, which is, has the state provided adequate justification for not treating us differently? So, my lord, that was my lords, my lady, that was what the Divisional Court said about the approach. Just check my note. Yes, there is discussion, my lords, my lady, about the difficulty that your lordship has posited, my lord, Justice has posited. 134, by reference to Carson. And in Carson, the Strasbourg court said, towards the middle of that paragraph, the court is not in a position to make an assessment of the effects, if any, on the many thousands in the same position as the applicants, and nor should it try to do so. Any welfare system to be worked for may have to use broad categorisations to distinguish between different groups in need. And the Divisional Court said the same reasoning applies to complaints of discrimination in the context of a taxation system. In our judgment, it applies squarely in the present context. To which again, our answer, my lords, my lady, is yes, but we say here you can make an assessment of the effects on this particular community. The evidence was good enough, and the Divisional Court made adequate findings in our respectful submission as to what this would mean for this community. And you can and must, as the ultimate safeguard against discrimination, decide, we say, that there isn't adequate justification for not treating us differently.
I'm not sure that's the point that's being made in the passage you're citing there, because what we don't have, for example, is evidence. If we declare this primary legislation to be incompatible because of these particular appellants before the court, what we don't necessarily know is what the knock-on effects may be on other people in society. Reference has been made to Muslim communities, there may be others, there may be non-faith communities who will wish to say that there should be a carve-out before us. And the point, I think, is that this court is not in a situation, either by reason of evidence or by reason of competence or democratic legitimacy, to be able to second-guess those kinds of judgments.
My lord, with respect, this court doesn't need to, because you only need to ask and answer the question about this community. If other communities, if other status groups wish to come to court and say, me too, then they can do so. And the court will assess the evidence in relation to their claim. But the declaration of incompatibility that we invite your lordships and your ladyship to make is solely about the position of this community and goes no further.
That may be so, but when we take our first step into the arena,
yes, my lord.
And we, undoubtedly, some would say, well, that is obvious judicial overreach because you're starting a hair running, which will undoubtedly, I mean, you can see it would involve other communities coming forward and saying, me too. I think they use the term in the judgment. And we would simply have said, well, it's not our responsibility how you sort it out, but you must sort it out. But actually, that directs us to the pre-existing question as to the margin of appreciation in a situation of this kind, when tax is concerned, revenue raising, manifestos, political legitimacy. I mean, at least you must see that it puts the court in, as my lord has explained, for all the reasons my lord has explained, it puts the court in a really, really difficult position. I mean, of course one has huge sympathy for the plight of your clients, and indeed maybe for other minority communities.
Yes.
But who is, I mean, my lord asked, who is to make this decision? Yes. And you're saying, well, you can just make it and stand back and say, well, look, this is not good enough. What you've done is not good enough for this community. And then sort of assume that it'll all be fine, but it may not be.
Well, my Lord,
we may
respectfully,
know now it may not be fine.
well, respectfully, not assume that it will be fine. Assume it will be dealt with by Parliament. And that is the function that this court has been given by the Human Rights Act in terms of the power to make a declaration of incompatibility, to say that at present, the evidence before us does not satisfy us that the failure to treat this community differently is justified, objectively and reasonably justified. That's all you are asked to do. At that stage, Parliament then will then consider whether or not to make changes in relation to this community. And if other groups wish to come along, which I know nothing about and have nothing to say in relation to, other than that's a matter for them at that time. So, respectfully, my Lord, the problem that you're positing would be based on a misunderstanding of this court's function in a human rights case, and a misunderstanding of how discrimination law operates. Because the Divisional Court has rightly found that we get to the justification stage.
Of course.
And so all that matters is there justification? And as I hope to go and show you
We
very
are
shortly,
talking about
there is none.
justification.
Yes, absolutely, we are, my Lord.
I must say, I find reading SC and the other cases that there's a lot of sort of what word shall I use? That it's actually very difficult to understand the competing factors where you have a situation where the democratic government has legislated and actually considered the issues with which we're concerned and decided the only option is the option they chose. So chucking it back at them and saying, that's not good enough, undoubtedly will open a can of worms. Of course it will.
Yes, my Lord.
And you say, well, your responsibility is to do it, but actually that's not the answer. The answer is, how do you perform the evaluation of deciding whether there was justification or not?
Yes, my Lord, and the answer we give to that is through a moderately intense level of scrutiny, asking the question.
I mean, I find all that moderately intense, super intense, incredibly confusing and unhelpful, to be honest, because although I quite understand the words,
yes, what does
we're
it get
dealing
to?
with some quite, I don't want to use more words that just make it more unhelpful.
I understand entirely, my Lord. I'm conscious of time, and perhaps it might be best if I answer that question by reference to the reasons the Divisional Court gave and why they did hold it was justified. Before I get there, I need to very briefly, if I may, touch on Schwidler, because we do say this is clearly a case where this court needs to conduct a proportionality analysis for itself. It's at tab 35 of the authorities, page 874, and the discussion from the Supreme Court of the approach to the appellate courts is at paragraph 142, and that's page 909 of the authorities. And we say this couldn't be clearer now, that the approach in this case must be a fresh assessment. The court sets out, Lord Sales and Lady Rose, the two potential approaches that could be taken. Two different approaches are identified by the authorities at the bottom of 909. In some cases, the appellate court treats its role as confined to a review to check whether the first instance court assessment in relation to proportionality was arrived at the basis of a proper self-direction, etc. And then the second approach, which is just below C, in other cases, the appellate court does not treat its role as so limited, but instead, in order to decide whether the appeal should be allowed, it makes its own fresh assessment of the proportionality of the measure. Each approach is justified in their proper context at 143. And 144, very importantly, we say, the fresh determination approach is appropriate where it is important that the appellate court should give its own opinion about the proportionality of a measure and its compatibility with convention rights, rather than defer to the assessment of the first instance judge. This is likely to be an important consideration in cases where the decision will provide guidance for other cases or where the subject matter has major social or political significance, so that the public will rightly expect the senior judges in the appellate court to exercise their own judgment as to whether the measure in question is proportionate and lawful or not. But we say that
I don't know whether you're going to take us to it, but it occurred to me, at least in pre-reading, this might be a case which falls within paragraph 160.
Precisely where I'm going next, if I may. So 160 is the paradigm case that the Supreme Court identified.
Yes. I just wonder if, for example, for the sake of argument, this court were to disagree with the divisional court,
Yes.
I wonder what Sir James's submissions to the Supreme Court would be on what their role is.
I expect they would be that they need to decide for themselves, my lord. But that's a matter for Sir James to answer, of course. Yes, so we say paradigm case, a case involving the first consideration at appellate level of a new legislative regime of general application, especially one with considerable significance for
I
society.
think on this point, two of us at least are quite familiar with
I'm grateful, my lord.
Fiddler.
I will move
And I
on.
think we'll let Sir James persuade us that we should
The other
not
one.
do that. Yeah.
I'm grateful. So if I could go to the divisional court's decision itself then, the 30 minutes I have left. I have done most of the groundwork, of course. It's paragraph 150. So we do say that the divisional court's approach, and we say, of course, you decide for yourself, but we say that it's wrong in terms of giving too much weight to the margin. So at 150, although the object of justification differs depending on whether the discrimination involved is stimulus or indirect, in a case such as the present, the applicable considerations are similar. We agree with that. In practice, the question is whether, in light of the reasons for not creating relevant exemptions, the decision to impose a uniform rule fell within the applicable margin of discretion. Now, if that's just a synonym for can be justified objectively and reasonably, then we have no complaint. But it's not, we say, correct to refer at this stage to the margin of discretion. What the divisional court should be asking is the failure to make the exceptions sought here, or failure to treat our group differently, objectively and reasonably justified? The breadth of the margin is no substitute for assessing the reasons given, and of course they've properly directed themselves at 129, we say, but the key question is the lack of differential treatment. There's then a further, we say, error, or at least a failure to properly appreciate the guidance in SC, in the last sentence of 150. In this case, we're considering a complaint of discrimination, which narrows the margin to some degree. And we say that fails properly to reflect the suspect ground principle that is set out so thoroughly in SC, and the need for cogent justification in those cases. Paragraph 151 looks at the practicalities. So the divisional court move, and we don't criticise this, to look at how it might be done. And the first is an exemption for all schools with the religious ethos. That obviously isn't appropriate. We say nothing about paragraph 151. 152 is the alternative of a narrowly drawn exception for the Haredi Jewish schools. The question would arise why families at these schools were being given preferential treatment. How could the characteristics be defined? We accept those are all important practical questions. We say that it is plausible that there could be an exception of that nature, relying on the very particular characteristics of the community, but it certainly was not and is not our preferred option. 153, we
Well,
agree.
presumably you say that the two critical features identified
Yes.
in 152 are not actually the critical features. The critical features are the finding that there is a requirement to have special education that is not provided in the state sector.
Religiously acceptable, my lord, at 149, yes.
Religious.
Precisely. So, 153, we accept the challenge that is put there in terms of the principle that it's legislatures that should be grappling with these questions. But we do say, of course, that ultimately the court still needs to be the safeguard for discrimination, and the divisional court hasn't properly performed that function here. 154 is the low fee exemption, the most plausible solution, and the reference to the government's evidence on that. So 154, a relatively modest loss. We accept that characterisation, respectfully. 155, the government, however, had both practical and principled reasons for rejecting such an exemption. There was a concern that schools would seek to bring their fees below the applicable limit, the gaming the system point. HMRC would have to devote significant resources to collecting and analysing data and to monitoring the conduct of private schools. The divisional court said, we do not completely discount this concern, but we doubt that it has more than modest weight, given the small numbers of schools involved, and the fact that even without any exemption of the kind contended for, the introduction of VAT is likely to incentivise the same sort of behaviour. And we respectfully agree.
On your, well, I know you, on this bit, you agree with the divisional court, But
Yes, my lord.
suppose we didn't agree.
Yes, my lord, I accept.
On
You-
Schindler, it would be open to us all here to say that actually we give more weight
It would.
to this consideration.
It would, my lord, and respectfully, I would argue that you should not, that the Divisional Court were quite right, not because they were the Divisional Court, but because on the evidence before them and before your lordships and your ladyship, that the evidence is that a potential loss of no more than 30 million, precisely how it's calculated, still remaining somewhat opaque.
But what does it mean to say it's modest? I mean, how do we decide what is modest in government terms? I mean, of course, we know that the economy of our country is much more than £30 million. But what's a judge doing saying this is modest?
My lord, respectfully, I would submit that you look at it in the context of the overall measure. And so the overall measure here is seeking to raise some 1.5 billion net. And in that context, it is open to the court to say that a cost of up to £30 million is relatively modest, and it should be given no more than
the
modest
other
weight.
faith groups, I mean, we don't know.
But that's a matter for them, my lord, respectfully,
Yeah,
later on. That's a matter for them.
I don't want to delay you.
No, I'm grateful, my lord, thank you. So that was the first practical reason that was considered, was the administrative complexity issue, or the gaming the system issue, I should say.
Your real criticism is 156.
Precisely.
Yeah.
So that's what persuaded the Divisional Court. Principled reasons, more substantial, carried considerable weight. The government's general policy is that non-denominational state schools should be and are capable of providing a broad pluralistic curriculum.
Well, you say that's inconsistent with 149.
With 149. It's not wrong as a statement of broad principle, but it doesn't reflect the practical reality. There are no state schools which are religiously acceptable for this community. And also the other finding that moving, or certainly the evidence from Mr. Pinter, that moving into the state school is not a realistic option for already schools. And certainly we know on the evidence that there are very, very few currently. And so that certainly even if that were an option for some, it wouldn't happen for some time. So that's principled point about the availability of broad pluralistic education, we say ignores the practical reality for this community.
Suppose, not giving you any indication whatsoever of what I'm thinking, but suppose we were to accept that submission, that they've fallen into error in the first 4 lines of 156. But if we're doing the proportionality assessment for ourselves, as per Schmidt,
Yes, my lord.
as you invite us to do,
We have.
could we still arrive at the same conclusion that the government has justified
Yes.
the failure to have a carve-out in your case, even though along the way there are 1 or 2 mistakes
Yes, you
in the
could,
reasoning?
my lord. Quite right, if I may respectfully say so. It's open to your lordships and ladyship to retake the entirety of the proportionality assessment. We can't have our cake and eat it. I recognise that. We can't have the bits we like and not the bits we don't. We do rely, of course, on the factual findings. That's very different in our situation. But on the analysis and the assessment, we say all options are open. But we do say that the points that the Divisional Court made at 155 are good. And we also go on to say, and it's of course a matter for my own friends how they put the justification, but to the extent that reliance is placed on administrative difficulty and inconvenience and the bureaucracy that would result, there is no compelling evidence, no cogent justification that lies in that regard. And of course it's not a factor that the Divisional Court considered at 155 at all. So entirely correct to say that the difficulty I have with Divisional Court judgment is 156. We've looked at the first point, which is the general policy. The second point is that there are ways in which private schools can move into the state sector. And again, it's the same error we say, which is that yes, that's true in theory and in principle, but not practically for this cohort of private schools. The significant changes that's referred to 4 lines from the bottom would mean essentially that the schools lose their Haredi character. They would no longer be Haredi schools.
Sorry, you state that, but there are some Haredi state schools. Are you
Yes.
saying they don't have the appropriate?
The evidence of Mr.
That's
Pinter,
not what
my
the
lady.
evidence seems to say.
Sorry, my lady. Yes.
It's more that they would take some time and may be impractical.
The school that we refer to in particular in Hackney, as I understand it, and the evidence is there, became a state school some 10 years ago. And the evidence is that it has become harder to meet the standards in the state sector over that time. But indeed, my lady, in our submission, it's enough that if it were possible for any of the schools to, and I don't represent all the schools, of course, and I'm instructed by all the schools, the practical reality is it would take a very considerable period of time. So we said that's not a good reason either. And then 157, referring to the government's evidence, putting the point delicately, but the thrust of it is that many of the existing small private schools serving Orthodox and Conservative communities do not currently meet these standards. Now, what's important in our submission is that these standards mean state standards. It's not that these are schools that are failing to meet independent school standards, it's that they don't meet the standards in the state sector. And we say, again, that's not, if it's relevant at all, that's not a weighty consideration here. Because this isn't a case about whether the schools ought to turn themselves into state schools. It's a case about whether the government is justified in not treating this community differently as things stand now. And although we do accept that what's said at 157, that any exemption for a particular group will necessarily be seen as a decision to grant special treatment, what it actually is a finding by this court that the failure to treat us differently is not justified, has not yet been justified.
Well, it depends what question you're asking. If you're trying to justify a carve-out, if you're talking about a carve-out for Haredi schools, then it may well be relevant to say they don't meet state standards, and we would be thereby encouraging schools that didn't meet state standards, which is a problematic for government policy. If you're asking about an exception for low-cost schools,
yes,
might be a different.
Well, that's certainly the focus, my lord. But again, we're not asking the court to make a finding as to which of those exceptions ought to be applied. We're asking the court to find that failing to treat us differently in any way is.
But the problem with that submission is its impracticality. That it's a lovely submission for you, Mr. Broach, and I understand why you make it. But actually, we can't just ignore, if it were the case, sadly,
yes,
that you could not find an exception. You agree?
I agree with that entirely, and that's why I said there's no bright line, respectfully to my lady's question. But you are fully entitled to look at the practicalities. And in fact, our criticism of the divisional court, in essence, is the obverse failure.
And I mean, have we checked your ground of appeal is specifically about failure to
yes,
recognise
the low fee exception. Yes, ma'am. That's entirely right. And that was our focus below, and this different team puts the same focus here. There's no difference here. But my lady, that's why we criticise the divisional court respectfully in 156 and 157, is that all of these points are fine in theory, but we say they ought to give way to the practical lived experience of our community, and the very good reasons, we say, based on history, based on the experience of anti-Semitism, based on their faith, that they will not take up the theoretically available offer of state education. Also keeping in mind that there is in fact no available offer of state education in Hackney at the moment. And the uncontested evidence was that there is nowhere near the volume of state places. So that's why we say the court does need to get to this level of detail in terms of asking, well, is this objectively and reasonably justified? So that's 156 to 157. 158 then is the if A, why not also B point. And we do say that is a misdirection by the divisional court, because any B contenders can come and make their case at the relevant time. What the court really ought to sort of restrict its consideration to is if A, or perhaps more accurately, why not A? So 159 is then consideration of the fact that this was a matter for Parliament, and that there was consideration in Parliament of the position of faith schools. Now, we've criticised in the grounds of appeal the reliance on the opposition day motion. The government relies on other considerations in Parliament, which are exhibited to Ms Reader's statement in the second supplemental bundle at 791 to 947. We accept that what that evidence shows, and what SC shows the court can take into account, is that the position of our community was before Parliament. There was reference in the parliamentary debates to the position of our community. And just briefly, if I can go back to SC, conscious of time, but how does that matter? We go to paragraph 182 of SC, paragraph 182 of SC, just find the page reference. 828 in the authorities. We have the guidance on how the extent to which the court ought to look at parliamentary materials. So the question, of course, is not whether Parliament considered the issue, but whether the legislation results in a violation of convention rights. Courts usually need to decide whether the legislation strikes a reasonable balance between competing interests, answering my Lord's point as to, well, is this really a question for this court? Or whether legislation is challenged as discriminatory, whether the difference in treatment has a reasonable justification. If it can be inferred that Parliament formed a judgment that the legislation was appropriate, notwithstanding its potential impact upon interests protected by convention rights, then that may be a relevant factor in the court's assessment because of the respect which the court will accord to the view of the legislature. If, on the other hand, there is no indication that the issue was considered by Parliament, then that factor will be absent. That absence will not count against upholding the compatibility of the measure. Of course, we'll simply have to consider the issue without that factor being present, nevertheless paying appropriate respect to the will of Parliament. And at 183, the courts should go no further than ascertaining whether matters relevant to compatibility were raised during the legislative process, if they are to avoid assessing the adequacy or cogency of Parliament's consideration. And the answer to that question here is yes, they were raised within the legislative process.
So you don't say 159 was inappropriate?
We say the Divisional Court focused on the wrong part of the debates, but that's, on analysis, makes no difference because 183 of SC says you don't go that far. You just look at whether the issue was raised within the parliamentary process, and it was raised elsewhere within the debates on the bill. And so we don't go any further than that. The distinction between determining whether as a question of historical fact the issue was before Parliament on the one hand, and determining the cogency of Parliament's evaluation of that issue on the other hand is real and must be respected. And towards trawling through debates should not therefore be necessary and as unlikely to be appropriate. A high-level review of whether a topic was raised before Parliament, whether in debate or otherwise, should suffice. So, yes, it was. What does that mean? We say it goes to the margin, it goes to the extent of the appropriate respect to be given, and it may be a relevant factor to the court's assessment. But what we say the Divisional Court did wrongly was treat it as at least part of the answer to the question. So they say, in our view at 159, the task of weighing up the arguments for and against an exemption was quintessentially one for Parliament. And having looked at the opposition day motion, we say that's not actually the relevant passage. In other words, at the end, the matter was before Parliament, which decided not to create any exemption. Well, yes, that is an inference that the court is entitled to reach. But what does that mean? Why does that matter here, when what must be justified is, well, why not treat us differently? The fact the matter was before Parliament doesn't answer that question. So it goes to the intensity of review point, which I shared some of your Lordship's concerns about, but it doesn't go to the key point, which is, well, why is it justified not to treat us differently? And then we say, fundamentally, at 160, what the Divisional Court failed to do was actually answer that question. So although the cogent evidence of the likely effects of the measure on already Jewish families concerned us, and despite our sympathy for the families, whose circumstances were in evidence before us, we have concluded that the decision not to create a legislative exemption covering their cases nevertheless fell within the margin of discretion, which must be afforded to Parliament in the circumstances of this case. To which we say, well, why? Where's the balancing exercise that needs to be carried out? Where's the analysis of whether the factors that were mentioned in the earlier paragraphs, in particular 156 to 157, outweigh the prejudice to this particularly vulnerable and marginalised community?
I'm sorry to,
Not at all.
to trouble you. This really lies at the heart of the
Yes.
appeal. I think your appeal. Suppose, for the sake of argument, we accept your critique of the divisional court. For example, they've asked the wrong question at 160.
Yes.
So suppose we ask ourselves the right question.
Yes.
Whatever that may be. We ask ourselves the question whether the government has, in truth, objectively justified
Yes.
the failure to have a carve-out which benefits your client.
Yes.
And that is reasonable and proportional.
Yes.
In assessing that question, can this court have regard to what the divisional court calls the margin of discretion afforded to Parliament?
Yes, my lord, in a rather difficult way, if I may make this submission, which is that the intensity of that review and the level and extent of the justification is what changes according to the margin. So if you're... Yes, my lord, I will. The nature and intensity of the review and the extent of the justification required is what varies according to the margin.
So it's how we go about it, but is also part of assessing the ultimate answer to the question. Because
Yes.
you said it's extent of justification as well.
So we say again, cogent reasons are required in suspect ground cases. And you have to ask and answer that question, are the reasons put forward cogent? And if I may, in the last 10 minutes I have, take you to what we say the government's main justification actually was. And this is my final part of the case, which is why I submit to you that you ought to find that there is no objective and reasonable justification here. We say the two witness statements that are particularly important. First of all, that of Ms. Whitehouse, which is in the first supplemental bundle at 217, in particular, paragraphs 53 to 55.
Sorry, which page is that?
217 in the first bundle, first supplemental bundle.
Just while I'm noting it, what's the other one?
It is Graham, paragraph 82 onwards at page 260. In particular, paragraph 90. So Ms. Whitehouse says at 53 that from the department's perspective, these suggestions will be administratively unworkable and bring the potential for abuse. Or we say in relation to A, that the divisional court will right to find that the potential for abuse was modest and essentially exists in any...
Sorry, just
system.
bear with me.
Yes, ma'am.
Yeah, you're at 53.
53A.
Yeah. I'm right. Okay, thank you. I've caught up.
And B and C. And indeed, D then is about the significant burden. Or we say in relation to all of that, that it's not that none of that is correct. There is some risk of abuse and there is some administrative burden. But that in a case like this, where the relevant group are so marginalised and so vulnerable, what would be needed to provide the kind of cogent justification for not treating them differently is much more than what is said here at paragraph 53. It would have to be essentially, in our submission, that the exceptions are unworkable, impractical, and the evidence at its highest, we say, doesn't come close to that. And that's equally true of paragraph 55, which has the open to abuse consideration. So yes, there would be an administrative burden, that's essentially 53. Yes, there would be some risk of abuse, but the divisional court will right not to be persuaded by that. Ms. Graham then at 260 looks again at the particular position of faith schools, highlighting the consideration that was given in the run-up to finalising policy of budget. And then at 85, noting the breadth of the cohort, including schools such as Eton. But at 86, officials considered in particular the possibility of particular impacts on certain subsets of schools, including ours, and identified that the 65 Jewish schools represented by Hinnock UK had average fees of £2,231, etc. At 87, not apparent that small faith schools as a cohort would be affected more by this policy than other schools. Well, we say that's not the position, and the Divisional Court were right to find, based on the government's own analysis, which is page 535 of the second bundle, that there would be a greater impact on them. 88, not considered that small faith schools would have significantly fewer reserves proportionally than those in the private school sector. Well, we know that Haredi schools do, uncontested evidence that they have incredibly low reserves, if any. 89 is then the policy principle. There might be some displacement of children from private faith schools. Government's position has been and still is that state schools are appropriate for children of all faiths and none. Well, we say that's wrong. State schools are not appropriate for the Haredi Jewish community. And in any event, they won't use them. And that's the evidence of both Hackney and the government that we saw earlier. We do reiterate the findings of the Supreme Court in Z and Hackney that I took your lordship's and ladyship to earlier in the regard of the community. So why not then do the carve out that's contended for, paragraph 90? First of all, it would be unfair. Well, we say not doing the carve out, of course, is unfair. Any threshold that's applied is always going to create a risk that people above the threshold are cry unfairness, but this is the best proxy that's been identified. Distort the market, we say that's not a consideration of any significant weight. Risk of tax avoidance, again, not any more than other issues within the system. Implementation challenges at D, we accept there would be implementation challenges and there would be administrative burdens, but not such as to outweigh the detriment to our group. Cost, we do say the Divisional Court were right to find that the cost of up to £30 million was modest. And then again, the principal position that state education is suitable for children of all faiths doesn't reflect the kind of granular analysis of the position of the Haredi community that the case law shows is required. And what we say is important coming from all of this evidence is this isn't a case where making the exception would itself undermine the key aims of the policy, which was the position in Humphreys. We say that in fact the key aim of the policy is to raise revenue and the impact there is modest, and that the exception would be consistent with any of the other aims. And so when the court asks that question, which is, has the failure to treat our community differently been objectively and reasonably justified? The answer is no. And we seek a declaration of incompatibility to that effect, which is of course my final point on relief. And the Divisional Court agreed this would be the appropriate relief in principle. That's paragraph 108. We say they were quite right in that respect. So unless the government can persuade you that the failure to treat our group differently is objectively and reasonably justified, and there are cogent reasons for it, that's the relief we invite. And also, Lady, may I just turn my back briefly just for one moment? Grateful. Very good. I've got the reference to my Lord Justice Singh's question, which is how the 30 million figure was calculated, and it's in the second of the supplemental bundles at 287 to 288, my Lord. Thank you. But it may well be that James is best placed to assist in that. Unless I can assist further, those are the submissions which outlines.
Yes, thank you.
Grateful.
Mr. Quintabani.
My lords, my lady, before I turn to the grounds of appeal on behalf of the evangelical schools, the parents and the children, I just want to make a few brief but important observations on the VAT measure itself and on the Christian education which is sought by the parents and provided by the schools. The first point was touched upon by my learned friend, and that's that the government has repeatedly, in these proceedings, sought to characterise the VAT measure as a measure which removes subsidies or tax breaks which private schools previously enjoyed. And we saw that the Divisional Court said that this was jargon, but nonetheless the government continues to adopt this language. And this may be understandable from the point of view of political spin, as it were, but it's legally and factually inaccurate. Private schools neither enjoyed tax breaks nor subsidies with regards to VAT. Prior to the VAT measure, no private charitable schools and no state school have ever been subject to VAT, and that has been the case since VAT was introduced in this country in 1973. And this was not a matter of applying a tax break, but the exemption was required by the law itself. And we see the EU VAT directive. We'll be having a look at that later on. The characterization of the VAT exemption as a subsidy is even further from the truth. There are many schools, other than the state-owned schools, that the government does in fact subsidise. We've seen these described in the witness statement of Susan Whitehouse and the first witness statement of Peter Lowe. The government subsidises foundation schools, voluntary aided schools, voluntary control schools, academies, and free schools. But the only schools which do not receive a penny of government subsidy are private schools. And this is an important point, because as we shall see when we look at the discrimination points that we want to focus on, whilst Article 2 of the first protocol does not require states to subsidise schools, it does require that any subsidy, or indeed any tax regime with exemptions, be applied in a non-discriminatory manner. And we say that that isn't the case here, and that's why the private schools are victims of discrimination as a result of this VAT measure. What we say the VAT measure is, in fact, is a tax on education. And this is not jargon from our side. It's simply an education tax. And once it's seen in this perspective, a lot of the problems with its compatibility with Article 2 of the first protocol become apparent. The government justifies the measures we've seen in part by the money that it believes it will raise, and according to the HMRC evidence of Catherine Peters at tab 22, page 179 of the supplementary bundle, the measure is anticipated, at least initially, to raise a net figure of £1.2 billion a year. And this figure is derived from a net VAT gain of 1.5 billion, less the 300 million a year that it will cost the state to fund the displaced pupils whose education was previously not burdening the state. Now, this is all highly speculative and relies on the measure only displacing to the state sector 35,000 pupils of the 500,000 currently in private schools. And we can see in the HMRC policy paper, private school fees VAT measure, which is right at the back of the reference supplementary bundle, the second supplementary bundle, at page 1010, we see the figures, the anticipated figures of how many pupils are going to be displaced. And it's anticipated that in the first year of the implementation of the measure, so the year which has just passed, the academic year which has just passed, that we would have 3,000 pupils displaced. And then this would rise over time to a long-term figure of 35,000. Now, I recognise the concerns that the court expressed before in terms of its institutional competence to get into the details of this, of the consequences of something like the VAT measure. And we accept the court is not in a position to determine if these figures are realistic or whether the revenue figures are realistic either. We have had, there's no expert evidence before the court on this matter. What the government does record in their evidence at page 239 of the reference supplementary bundle, paragraphs 70 to 72, is that a survey involving 90 schools was conducted by Baines Cutler for the Independent Schools Council. And this survey anticipated that the total number of pupils displaced would inevitably be a minimum of about 85,000, that's 17.1% of 500,000. But that a reasonably likely displacement could be 127,000, that's 25.4%, that they, at the upper end of their estimates. Now, the court has the benefit of the latest evidence from the ISC. This is the third witness statement of Julie Robinson. And this shows that up to the beginning of this academic year, 25,000 students have left the private sector. At least have left ISC schools, and the ISC schools are only 55% of the schools within the private sector. So that figure, and again, I appreciate the court isn't in a position to determine what's realistic or not, but we can note that that figure is more than 8 times the 3,000 pupil loss that was anticipated by the government in the first year. And all we want to note is this, that adopting the government's methodology and their way of calculating revenues from the VAT measure, if the final displacement of pupils from private to state schools is 5 times that which the government has anticipated, and so far potentially we're at 8 times already in the first year, then there will be no net revenue gain to the government from the VAT measure, because the cost of having to educate all the additional students will outweigh the VAT revenue obtained from taxing private schools. And of course, any larger displacement would cause a loss. I would now just like to look at the education provided by the evangelical Christian schools, and we would like to echo the criticism that my learned friend made on behalf of the Haredi Jewish schools, and that's the suggestion by the state that the state does provide free schooling supposedly suitable for all children, and that therefore there can be no breaches of the appellant parents' rights to obtain an education for their children. What this argument ignores is that the schooling provided by the state is simply not suitable for the evangelical Christian claimants in this claim. And what is also the fact is that, and this is clear when we consider that the claimant's evidence in the light of recent Supreme Court decision in a case called JR 87, that the sort of schooling that the evangelical parents are looking for, and that the evangelical schools are providing, cannot as a matter of law be provided by the state sector. It would be unlawful for the state to teach in the way that the evangelical parents require for their children. And this is because if the state attempted to provide the sort of education which the evangelical parents require for their children, it would constitute state indoctrination, which would fall foul of Article 2, Protocol 1's prohibition on this. Now, just as an aside, the word indoctrination has negative connotations, but it shouldn't. All that Article 2 prohibits is that the state isn't allowed to indoctrinate, but parents and private schools have every right to indoctrinate pupils, that is, to teach them the doctrines of their faith or beliefs, and to present these doctrines as being true over and against those held by any other faithful belief system. And this is a right which is, when exercised privately, is guaranteed by the common law, by the human rights instruments which we'll be looking at, and by Parliament. If we could have a quick look then at JR 87, which is at tab 36 of the authorities bundle, starting at page 951. And this was a challenge to education provided in a Northern Ireland Christian state school, which was held to breach the rights of the parents who did not want that sort of education. And the Supreme Court records the parents' concerns at paragraph 21 on page 957 of the authorities bundle. And this is what the court says. Both parents are primarily responsible for the education and teaching of JR 87. They do not wish her to be raised as a Christian, They object to her being taught at the school to assume that Christianity is an absolute truth. Their concerns as to religious education and collective worship at the school are heightened, given that she's been taught at an age prior to the development of her critical faculties. And then at page 960, paragraph 32, we see the father's concerns described further. By way of illustration, G states that in the absence of any religious exposure at home, his daughter now believes that God made the world, and she repeats and practices a prayer grace that she was taught at school at snack time. His concern is that his daughter is learning Christianity and not learning about Christianity in a school context that effectively assumes its absolute truth and which encourages her to do the same. And the court went on to find then that this constituted indoctrination, the state couldn't engage in it. If we look at just a couple of the statements of values which the schools have put forward, we'll see why arguably what these evangelical schools are providing goes even further than the school in Northern Ireland. I'd ask the court first to look at the statement of values of the branch Christian school, which is at tab 15 of the supplementary reference bundle, page 138. And there we see that the statement of values says that the school's providing is Christ-centered. Jesus is at the center of everything we do. And then if we turn over the page and we see what the school's objectives are, we can see that for the students, the objectives first is that each one will accept the Lord Jesus as their personal saviour, and secondly, that each one will grow in his, her faith to become an obedient disciple of the Lord Jesus Christ. Similarly, if we go to tab 18, page 145, and we have the Wycliffe School's Memorandum of Association.
Which page?
145.
Thank you.
And there we see this at paragraph 3. Oh, sorry, page 146. The objects for which the association is established are to promote and provide for the advancement of Christian education in Mid Glamorgan, South Glamorgan and Gwent, in which every aspect, including the curriculum, is subordinate to the Bible and is in accordance with the philosophy of Christian education and statement of faith as set out in Appendix 1 and 2. And if we turn over 2 pages, we can get to Appendix 1, the educational philosophy and statement of faith. And we see at 1, God is acknowledged as sovereign in creation, in sustaining creation, in salvation, and in all world affairs, which is to be the basis of the teaching of all subjects, avoiding any teaching which exalts man above God. All curriculum material is to be selected and controlled in accordance with the statement. The supreme and ultimate standard and absolute rule of faith for life of this company is the Bible, the entire revealed and inspired Word of God. So we say that the only way that parents can obtain the religious schooling that they require for their children is privately. It's simply not available in the state sector, and there aren't any schools in the state sector which are currently providing that education. There's a suggestion, and my learned friend criticised it too, that there's a suggestion from the government that low-cost religious schools are not able to provide as good an education as that provided in the state system, and that these schools are somehow inadequate and hence unworthy of support. In fact, the evidence before the court is entirely to the contrary with respect to the evangelical schools in this claim. They're obtaining good inspection reports, and their small class sizes, the dedication of their teachers, and the wholesome and loving environment that they have is ensuring that the pupils thrive. That concludes my introductory remarks. It may be that...
Is that a good time?
Maybe a good time.
Well, we'll resume at 2 o'clock.
Court rise is able.